Hello and welcome to Contracts 101, sponsored by the Los Angeles County Bar Association and Syracuse University's Institute for Veterans and Military Families. My name is Amy Lauren, and I am a senior associate at Orrick, which is a law firm, and I'm happy to present to you today some of the fundamentals about creating a contract. Really, what is a contract? I think everybody feels as if we know what a contract is, but in order for a contract to be a legally binding contract, it has to have a few special characteristics, and I'm going to go through those. So if you're getting into business and needing to enter into a contract, you should make sure that you've got these crucial elements in your document. In its broadest terms, a contract is an agreement with two or more people or companies to do something or to not do something that you don't have a legal duty to do or not to do. So it's basically two people or a person and a company, two companies getting together and deciding that they want to get into business together. They want to do something where each party has an obligation to do something. To make it enforceable, is basically the idea that it's a legally binding document, so that if one person is not fulfilling its obligations, there's actually a legal recourse that the other person has, and they can go to court and enforce their rights under the contract. So what you're looking to do when you're in business is to create an enforceable contract, and that's what must have the characteristics we're going to go through. There are always three components of a contract. First, there's an offer. So one party must make an offer. Second, there's acceptance. So the other party has to accept the offer. And lastly, there's what we call in the legal business consideration, but in that each party must gain value. So the offer can be simple as an offer to sell goods or services. So if somebody's offering their hosting services for a server, for example, you want to host your website on a server. Somebody has a business that offers that. If you'd like to host your website using their website hosting services, you can accept their offer. Their offer usually consists of a bunch of different terms, including what we call consideration, which is I will give you these services in exchange for a price. So it's really the exchange of money for goods and services that you see most of all for consideration. It doesn't always have to be money. Sometimes you can exchange something of non-monetary value. For example, if someone has hosting services that you would like and you're a website developer or designer, you can actually offer your services to that company in exchange for their services, and that can be the consideration. It doesn't actually have to be money. Well, what else do you need a contract to have in order for it to be enforceable? Well, there are some essential sort of rules around making a contract enforceable. One is that each party has to be capable of actually entering into a contract, and this is by law in each state. There are certain reasons why parties are not actually able, or a person or a company is not actually able to contract, and that would be one, can't be under the age of 18 in order to enter into a legally binding contract. You have to have the mental capacity to enter into a contract. So we call it you have to have the meeting of the minds. So two people actually have to consciously get into a contract together. One party can't, be tricked or be, not have the capacity sort of mentally or to actually get into a contract. Both parties clearly have to consent to all of the terms in the contract. You can't hide anything from one party or the other. The subject of the contract has to be lawful, so you can't do anything that's against the law in the state that you're contracting in, but of course you probably won't be doing that. And you also must be, giving something of value, for example, money. And then I think one of the other issues that people can think about often when they're talking about contracts is, well, do I have to have it in writing? Or what if we just agreed on something? Well, most states actually do honor oral contracts, California being one of them. If there are those crucial elements of the contract that we talked about previously, if there's an offer, if there's acceptance, and if there's consideration, you will have a contract, even if it was merely an oral agreement. But actually, it's always best practice to get it in writing. A written contract is something you'll always be able to rely upon if there's an issue, if somebody claims that they did not agree to something. If you have a written document that both parties have signed, it's always the best practice. That being said, if you know that somebody, say, has agreed to do something, for example, pay you for particular services that they've offered to you, you may have a binding contract. You should talk to an attorney about that because it depends on the state that you're living in. But the general rule of thumb is really to get into the habit of putting your contracts in writing. Now, contracts may be either express or actually implied. Again, an express contract is always the way to go, a written express contract where it's very clear that what the parties have agreed to, that I've offered my services for this amount of money, and there's no question as to kind of what's happening here. But sometimes there is an implied contract, and that's one where the agreement of the parties is shown by their conduct rather than by their words, and then the law will say, can say that, well, because the parties have been behaving in a certain way, we're going to imply that there's an actual contract between the parties. And an example of that could be in many states, if you have an agreement to, say, receive services every month for website hosting, I'll use that example again, and you pay a certain amount every month. And that's been, say, your arrangement for the last year or so. If one day somebody decides, one party, the party receiving the services decides to stop paying for the services, it's possible that the party that was providing those website services, if they provide them again, as they have been, and every month in the last year, that there would potentially be an implied contract that they were owed the money for the services that they were provided because the party's conduct was such that they had been behaving in a way as if there was a contract in place, even a written contract in place that said, I will provide you these services for this amount of money and you will pay me every month. If that's what you guys have been doing, then it's very likely that there could be a legal contract in place, an implied contract. There are different kinds of implied contracts. There's an implied in fact contract and an implied in law contract. Implied in fact is one where the party's conduct has created a reasonable expectation of certain performance by both parties, often based on the parties' former dealings. And that's the example that I was giving in terms of the services that were provided maybe in an oral contract. On a regular basis. There could be an implied in fact contract there. An implied in law contract is when a party has conferred a benefit on the other, which the other has knowingly accepted, and if they would refrain from the benefit without paying for its value, that would be an implied in law contract. Truthfully, we could see that as also being the case for the factual scenario that I painted before, in that if the website provider provided the services as they always did every month to the website owner and they weren't paid for it, the owner of the website would be unjustly enriched. So there's a couple of different arguments that you can put in for an implied contract if you feel like that's necessary. Again, always having something in writing is something that I think this probably won't be the last time that I'll say that. So what are the terms of a contract? I've already referred to the word party. I'm talking about parties. That's really the entities or the people who are part of the contract. Each one is a party to the contract. Together, they're the parties. When you're creating a contract, you want to make sure that you're writing down the full legal names of the individuals or the entities entering into the contract. So, for example, if you as a small business provider, if you have created an LLC or some kind of a corporation, you should make sure to use the name of that company as opposed to your own personal name, because you want to make sure that it's that company that's liable for the obligations under the contract, whether that's the obligation to pay somebody who's giving you goods or services, or it's the obligation to provide services. You want to make sure that it's the company that is responsible for those things and not you as a person. To the extent that there are problems in delivering those services or problem with paying for those services, it's better for the company to be liable for that than for you as an individual. Again, if you've created that company pursuant to legal advice, which I would advise, you should feel free to ask that lawyer, well, what is the liability of that company if I enter into this contract? I think that's something that's important to understand. Moving on, the terms of a contract also include definitions of the most important or frequently used terms. And that's always a really good idea, because I think we can say things in many different ways. And if we're trying to convey that a contract means one particular thing, that there are certain responsibilities that somebody has to provide goods or services to another party, I think it's a good idea to define, for example, what the services are that you're going to be providing, and then you always know what services you're talking about, because you're referring to them in that way every single time when you talk about services in a contract. It avoids ambiguity, and honestly keeps everyone on the same page, which is something that you always want to do in a business deal. You're going to see some introductory material at the beginning of a contract that might be called recitals or whereas provisions. And, some people just call that boilerplate or don't think that's really important. Now, while those are not obligations of a contract, it is an introduction that basically gives people some background. It's not essential, but it's helpful to show what I was talking about before in terms of the meeting of the minds. And I think, to the extent that, you want people who are working for you, working with that contract, maybe you're not available for some reason to explain what that contract is, but they need to have information about that contract. It's helpful for them to see what that background was and why you entered into that agreement. Just a few sentences is really something I think that's expected, but it could be longer. The deal terms then are the kind of the meat and potatoes of the agreement. It's the rights and responsibilities of each party. It contains the financial terms. It contains the operational terms of, when the services will be provided and how, for example. There's what they call a term, which is the length of the contract. Not to be confused with the terms of a contract, which are the different business terms, but the quote-unquote term, capital T term, is really considered to be what's defined as the length of the contract. When you consider how long to enter into a contract, I think it's important to, think about, how long do I really want to be in this agreement? If you're not sure, it's probably a good idea to think about doing it in, say, 1 or 2 year increments. You can have renewal periods in the agreement. The parties have the opportunity to renew pursuant to language in the contract. I think that's always helpful if you think you might want to renew the contract. If you know you definitely want the contract to renew, you can push for what we call auto-renew provisions, which means something to the effect that the term of the contract after the end of the first, initial term, say the end of the first year, the contract can actually terminate but be automatically renewed for a certain period of time, say for an additional 12 months, unless something happens. For example, unless one of the parties wants to terminate 30 days before the end of the term, and you get written notice 30 days before the end of that initial term that you do not want to terminate. Or maybe you say, there's 30 days before the end of the term, I want you to tell me that we are renewing. We mutually have to agree that we are going to renew, or this agreement's going to end. So, I mean, the beauty of contracts, especially when you're talking about business contracts, is that they are really flexible in a lot of respects, and you have a lot of flexibility to decide how you want to get into business with the other party. Term is one of the most flexible that you'll encounter. Sometimes you might, for example, want certain triggers, like business triggers, to incentivize the renewal of a term. So let's just say that you're getting a service provider and that they're going to be selling something for you, like a distributor is going to be selling some kind of product that you've decided to manufacture. They're going to be selling that for you. Well, maybe you only want to renew the agreement with them for another year if they've sold a certain amount of inventory. So that can be their incentive to sell that amount, is that they want the term to continue because they want to keep doing business with you. And the reverse of that is if they haven't sold that much, you don't want the term to continue. So then you end the agreement. Tied to term is, of course, termination, as I've already touched upon a little bit. But think about why you might want to end that relationship. What if the other party doesn't hold up its end of the deal? How do you want to just end the relationship? Do you want certain things to happen so they improve their performance, and they have a certain period of time maybe to improve their performance, like 30 days, 60 days, something like that? You notify them that they're not performing, and if they improve in 30 days, the agreement can continue. If not, maybe the agreement terminates. Maybe in a year's time, you don't know if you're still going to be in business, or you may think that your business priorities might change, and you may need a different kind of, let's stick to the distributor example. If you're selling goods, you might need a different kind of distributor in 12 months because you think you'll scale to a point where this distributor is just too small for you. Then you might really want that contract to end after 12 months. What if you think you may be at a point where you may not have raised the money that you want to raise? You may want what we call termination for convenience, or just a unilateral right to terminate the agreement. I mean, that's possible. Like I said before, agreements are flexible. Business deals can be negotiated in pretty much any way that you want to. Of course, the other party has to be willing to agree to that, but a unilateral or one-sided termination right is not unusual. You do find that, especially if you're the customer in the relationship, where there's a service provider or distributor on the other side. I think you're going to find that customers do have usually more leverage in those situations, because the providers want your business. Maybe you will be shopping around and you'll have found, you think, a better partner to get into business with. That can be on either side. I mean, you may be a service provider and you are getting into business with a customer that you're not really sure if they're going to be a good customer. You're not sure if they're going to really be able to produce the kinds of goods or the number of goods that you think you'll be able to sell. And so it's just not worth it for you, maybe at a certain point, to be in business with them, and you can find a better partner. You really might have doubts about this particular customer, and so maybe you also want a termination right for convenience, or you want to make sure that you can end that deal in 12 months. Just certain things to think about. Different terms can really influence sort of your thinking in terms of whether you want to, how long you want the term to be and when you'd like to end that relationship. Moving on to some of the other terms that are, kind of look more like kind of legalese when you're looking at these contracts. If you're not familiar with contracts, some of these terms can be a little daunting. representations and warranties are something that are almost always in an agreement. Indemnification obligations and then limitations of liability. You'll also see these terms and these kinds of provisions in contracts. And so, just to dispel some of those sort of the sort of, I guess, sort of frightening nature of how, being unfamiliar with some of these clauses are. These are really all three of these categories, representations and warranties, indemnification, and limitations of liability are all ways that a contract helps to allocate risk between the parties. Representations and warranties are, they're basically statements of fact and that you actually, for example, own the products that you're selling. Again, taking the distributor and customer example, and I represent as the customer that I own these products and that I have the right to sell them. What it gives you in that particular case is, it will give the distributor, if that statement ends up being untrue or somehow inaccurate, it gives the distributor a cause of action, which basically means that the distributor could sue the supplier or the customer under that arrangement, because it's problematic to have to sell things that the customer doesn't own, because the rightful owner might actually come out and say, hey, wait a minute, I didn't give you the right to sell that, and you think you did have the right to sell it because you've got a contract. Well, if that happens, you want to make sure that your contract is an enforceable contract that gives you the right to have a cause of action against that fraudulent seller. So if there's a representation in that contract that that the customer actually owns that product and has the right to sell it and ends up being untrue, you can take them to court and you can get a remedy for that to the extent that you've suffered any kind of damages, which could potentially happen if that true party, say the true owner, sees that you're selling these items that they actually own and did not give you the permission to sell. They might actually sue you, and then you will incur legal fees, and you having to then sue your customer will incur additional legal fees. So what you're going to want to be able to do is be able to get a remedy from this fraudulent seller so that you can make yourself whole again, or for all of the fees that you have to spend in connection with potential liabilities that you will incur because this customer lied to you. You want to make sure that you can recover that from this fraudulent customer. An indemnification clause does the same thing. Again, it manages the risks, and that's what I mean by the same thing. And it basically will require one party to pay for the loss suffered by the other. So not only could you sue for, in the same case of the customer not telling the truth about whether they had the right to sell a product, not only could you sue them for a breach of contract under this representation and warranty if they said that they owned, then had the right to sell this product, but if you have an indemnification obligation from that customer as well, that basically says that I will, as the customer, pay for any losses that you suffer if anything I say, for example, is not true, or if I've breached anything in this agreement, I've breached a representation in this agreement, then I will pay for your third-party costs. So not only could you potentially get some damages from their breach of the representation itself, but you also have an obligation that they already have in the contract where you shouldn't have to sue them, but they actually are obligated right out of the gate to cover you on those costs. So it's a very important provision to have in an agreement for something that isn't your fault, that you had nothing to do with, and you're going into this contract with all the best intentions. And if your partner did something that the other party did something that basically caused you damage in connection with the contract, they should cover those costs for you. So that's court costs, it's any damages, direct damages that you had, and that's a really important provision of the contract to put in. Again, they are complex, as you can tell. I hope I'm explaining them clearly, but they are complex and they take a little while to get the hang of. And it's one reason why I think having a lawyer look over a contract that you're thinking about entering into and concentrating on these risk provisions in particular, I think is really important when you're thinking about working with an attorney. Lastly, the limitations of liability in terms of sort of risk allocation. Basically, as I was saying, contracts can be negotiated in a lot of different ways. You have lots of flexibility. The parties can actually agree how much money is recoverable for different breaches of the contract. You can actually put a dollar amount on one of the parties' liability under their contract, both of the parties' liability under the contract. Usually if it's someone's providing services to a customer, the services provider is actually doing all of the work under the agreement. They're the ones that will probably have more liability under the agreement because they have more obligations. The customer doesn't usually have as much. Oftentimes they're just paying for the services, paying for the goods that they ordered. But not always. For example, in the customer example I noted above, if the customer is providing goods for you to sell as a distributor, well, then the customer does have some responsibilities there. So they won't have maybe less liability than you under the contract. Oftentimes thinking about how much money should be recoverable under the agreement, you think about how much the contract is worth, how much is going to be paid under the agreement, how much is anticipating being made in terms of money under the agreement. That's often the metric that is used by contracting parties to decide what kind of damages would be recoverable in a contract, but not always. Sometimes you have more risk. For example, if I'm a small company that is, say, using a payments provider to help me process payments for the goods that I'm selling to customers, well, the payments provider is going to have some personal information from my customers, so I'm going to want to make sure that there's at least some recoverability in that payment agreement if I can from that provider, because my customers are not going to be happy if there's a problem with the information that they've provided. I think if you don't have a limitation of liability clause that actually limits how much money you can recover for contract breaches, you will, in most jurisdictions, meaning most states' law, you will have almost uncapped liability in almost every situation. That's not what you want. Uncapped liability basically means unlimited liability. You have to think about it, and that's why many parties to contracts do think about limiting the liability to the amount of money that's being paid under the agreement. Again, these are risk analyses that are complex and do help to discuss with a lawyer for your particular context. Some other terms of the contract include the assignment clause for smaller companies that are, say, looking to potentially raise money, looking to potentially merge or be bought out at some point in time. You'll want the right to assign your contract. Basically means if you are, bought by another company, you may have to that new company may actually have to adopt the agreement. You would want that. And investors and others who are looking to, invest in your company or actually buy your company, they want to know that there aren't any limitations in the contracts that you have, especially the really important ones. At the very least, take a look at the really key agreements that you have that help fuel your business, and try to make sure that you have the right to assign your rights and duties really under the contract, and in particular, and at the very least under, in the case of a sale of all or substantially all of your assets. On the other hand, you may not want the other party to assign their rights or duties. In particular, when you have a service provider relationship, you really don't want them to usually to assign their services to another company that you haven't vetted. You don't know who they are. You don't know if they're going to provide you with the service at the same levels, even if they agree to take on that contract or have that a contract assigned to them. You haven't chosen them or done your due diligence for them, so you may not want the other party to have the right to assign the agreement in that case. And just running through some of the other provisions, force majeure is another sort of, mysterious provision sometimes, which essentially establishes that the agreement can be suspended if there are unforeseen circumstances, really disasters, such as, earthquakes, hurricanes, floods, war, terrorist attacks. I mean, really, they're meant to be used only for extreme circumstances like that. If the business burns down, I mean, really big things. You should look at that clause, though. It's not just what people sometimes call boilerplate or something that's typical in every contract, and you don't have to look at it. I would not say that about any provision of a contract if you're signing and making it an enforceable contract, because it could be used against you or give you an obligation that you're not aware of if you don't read it. But sometimes people get sneaky and try to use this clause not for extreme reasons, but say they're a service provider and they want some flexibility and being able to suspend the agreement. Well, what if their services are, go down because they just go down. They haven't been really paying attention to their systems, and they haven't hired the right people to monitor their systems. You know what? That's not a good reason to invoke a clause like this. It should be reserved for very extreme circumstances. If the company isn't doing what they've said they would do, if they're not providing the services that they said they would provide to you, you should have an enforceable contract that you can use to basically compel them to provide those services, whether you have to sue them or remind them of their contractual obligations to you. You should consider alternative dispute resolution, which basically is, do you always want to go to court in order to have your rights enforced or enforced against you? Or do you think you'd rather be in a more of a mediation or arbitration situation? Kind of really just depends. Oftentimes, I think it's easier to arbitrate for smaller companies. You're generally getting into business with other companies that are also small. The larger companies, in terms of hosting providers and things like that, phone companies, telecommunications, they're all going to require arbitration anyway. So those, you should just be aware of, but it's really those contracts that you're consciously getting into in terms that you can actually negotiate, not with, your telecommunication providers of this world, but with, your distributor, your suppliers, etc. You should think about whether or not mediation or arbitration is maybe a better bet than needing to take that supplier to court or having them take you to court. Remember, that could be with a jury. You can always waive that right if you just want to be before a judge. But again, this is a legal issue that you'd want to talk about with a lawyer. You'll see a choice of law governing law provision, which will dictate which state laws apply in a particular dispute. Again, I think talking to your lawyer is good there, because it really will depend on the kind of contract that you're entering into. Certain goods and services are, you're sort of better off contracting under certain states' laws than others, but oftentimes you can just contract under your own state law. Venue is where a lawsuit must be filed, so it's basically where you need to show up in court. And so you generally would want that in a convenient location that's convenient to you, or maybe halfway between the country for both parties. So I think we should turn to when contracts are broken, when you have disputes, because this is where kind of the rubber meets the road sometimes with contracts and the way that a contract is written. It's when, one or both parties, maybe one accuses the other, or they both accuse each other of breaking their obligations under the agreement. We call that breaching the contract or breaching a provision of the contract. And I've used that already. Now, when a breach of contract happens, one or both of the parties, you may just want the contract enforced. You just want the other party to do what they say they would do. You just want them to pay you, or you just want them to provide the services to you. And maybe that's enough. So, you can go to court and you can require that. You may not need money damages. You may just want your attorney's fees to be paid, or the fees that you needed to spend in order to have to take them to court. You may just need those to be paid. And you need a court order to force them to actually perform what they promised they would under the agreement. But sometimes it's worse than that, because when they didn't perform, sometimes when the other party doesn't perform, it means you suffered more than just having to take them to court, and you're not just made whole again if they start performing again. So for example, if you have a website, going back to that example, you're the website owner and you've contracted with a website hosting provider to host that website, and the hosting provider stops providing its services for whatever reason for a certain period of time, and your customers can't get to your website, so they can't buy your goods. They can't contract for your services because you do everything through your website. Well, you may have lost money as a direct reason, as a direct result of their failure to provide your services. And you may be able to recover some of the damages that you lost in that particular case. Again, disputes, tie back to those risk allocation provisions that we talked about before, those representations and warranties, those indemnities, and that limitation of liability provision. You do want to make sure that if you think you might need to recover damages at any point in time from, say, your service provider in the website example, that you are going to be able to recover enough to help to make you whole if there's a problem. So this is how these contracts are all, the clauses in these contracts are tied together. Monetary damages, we talked about that. Specific performance, that's exactly what I was talking about before. That's where you get a court to say, like, hey, you need to fulfill the promise that you made to me. And there's just for your reference, some different remedies that you could get to the extent that there's a contract that's broken. There are different kinds of damages that oftentimes are hard to prove, that are not direct damages. So direct damages really are, but for the lack of performance by the other party, or the lack of its performance under the agreement, the fact that a party did not live up to its expectations or its promises in the agreement, and if they had, or if they do not do that, then you have damage. That's a direct damage. So, but for their lack of compliance with the contract, you would not have had a damage. Then you would have direct damages from them. Indirect damages, consequential damages, punitive damages, these are damages that are less likely to come about because we're talking about all kinds of things that could happen that are not directly the cause caused by what that party did or did not do. And so here's just some contracting tips. I knew it was going to come up again, but keep everything in writing. As I was saying before, oral agreements may be binding, but they really are going to be difficult to enforce in court. Certain things really have to be in writing. In particular, I think in California, real estate related contracts really have to be in writing. Different states have different requirements there. So I think you're just better off always getting your agreements in writing. You've just got a document then that clearly spells out each party's rights and obligations, and there's just no real confusion then. And I know everyone's seen long, complicated contracts, and I certainly am guilty of dealing with those myself, but honestly, the shorter, the better, the clearer, the better. I think clear, plain English language is exactly what you want to do. Each party has to understand it. It actually can be, a contract can be deemed not enforceable. A court might say that the contract isn't enforceable if one of the parties doesn't really understand what they agreed to. You may agree at the time, you understand what that language says, even if it's a little unclear. But if you don't actually make it clear, I think to somebody who wasn't necessarily involved in the negotiation of a transaction, that could be really problematic down the line. So keep it simple. When you're negotiating a deal, make sure that you're talking to the decision makers. The last thing you want is a business, to do a contract with somebody who is maybe a little bit lower down on the totem pole, so to speak, or somebody who's more junior in a company who doesn't really have the authority to bind the business. And the business then, the senior leaders of the business come along and they either, refuse to abide by all of the things that you've actually taken the time to agree to and negotiate, or they refuse to comply, to honor the contract at all, even if it's signed. So I would confirm that you're negotiating with somebody who has authority to create to bind the business to obligations. You also want to make sure the business performs its obligations under the contract. So you want to understand what they're obligated to do, and you want to keep tabs on it. Some people say that a great contract is something that you negotiate and then you put it in a drawer and you never look at it again. I don't really believe that, because I believe that contracts, for better or for worse, they should be clear, and if you have questions about who's doing what, it should be very clear in an understandable document that you can refer to time and time again. If you're referring to that document regularly and you're keeping tabs on the other party, making sure they're performing their obligations under the agreement, I think you'll be in good stead. Again, use the correct entity names to make sure that the right entity or person is liable for the obligations under the agreement. So make sure you include all the details too. Judges may only look at the four corners of a contract. There are a lot of very specific rules about what kind of information, once you're in court, what kind of information can you bring into a contractual dispute that's not in the contract. Sometimes you can't bring anything else in. So don't leave any details out that were agreed upon and discussed verbally. If you feel like those are key things to the relationship, then you should actually put those into the agreement. So if you forget something, it's not the end of the world. Go ahead and create a short contract amendment if it was something that you talked about or something that you really fairly believe should be in that agreement. Then just tell them that you want to put an amendment in, and generally parties are reasonable about things like that. Payment obligations, again, you should be very specific about that. When payments should be made, who pays whom, what are the conditions for making payments, little things like at what time of the month, 30 days after the end of each month, the first of every month. Is there any work that needs to be completed beforehand? Does somebody have to approve the work that was done before you get paid? Are there installments or is there an advance up front? I mean, all those things should be very, very clear, so that you make sure you get paid, or that you're not paying too much, either up front or at all. So Again, we talked about terminating the contract. We also talked about resolving disputes. I think I think you will always want to resolve a dispute outside of the courts and outside of some kind of a formal dispute resolution process. First, I think you can put something in your agreement that talks about an escalation if there is a dispute, meaning an internal escalation. So if there's a dispute that the people who are running the contract can't handle, maybe the CEOs of the companies then have to mediate the dispute. Oftentimes the disputes can be resolved that way because neither party wants to really enter into a formal dispute process, whether that's through the courts or whether that's through even arbitration or mediation under the contract. One last thing I'll really cover here, I think, is confidentiality. You want to always make sure that if you're exchanging sensitive information, even the information that you're doing a contract with the other party, you may want that not to be public information. You want to make sure that each party is, responsible for keeping certain information confidential, and that you take that seriously. You will want to make sure that even if there is a confidentiality agreement, that you're only providing the other party with the information that they need to perform under the agreement. But sometimes there's sensitive business information that needs to be revealed, and you want to make sure that it's kept confidential. If you have done a non-disclosure agreement before entering into a contract, consider whether or not you could just reference that non-disclosure agreement in the as applying to the contract and everything, all the information that's exchanged under the contract, instead of rewriting all of the confidentiality provisions. But be careful, because you want to make sure that the non-disclosure agreement terms are broad enough to encompass what you need for what's actually going to be exchanged in terms of confidential information under this agreement, because sometimes it might be too limited. And that's all I have for today with for Contracts 101. I know it's a lot of information, but feel free to review the deck, and I hope that whatever you do with your contracts, that you have a successful experience, and hopefully this was helpful. Take care.